Perfect. Okay, so everyone, welcome to the Estate Planning and Intergenerational Wealth Transfer webinar with our special guest, James Simon, all the way from Renew Wealth Management. Before we begin, I want to do a quick disclaimer. So, Zoe Financial Inc. is an investment advisor registered with the U.S. Securities and Exchange Commission. Registration does not imply a certain level of skill or training. This presentation is not to be taken as investment advice and should not be relied on for such advice or as a substitute for consultation with professional accounting, tax, legal, or financial advisors. The observations made are independent of Zoe Financial and should not be read as financial recommendations. So, to meet our host today is Andres Garcia Maya, the founder and CEO of Zoe Financial. Andres was an executive director at JP Morgan Asset Management, where he led emerging markets research and strategy. He began his career at Morgan Stanley and frequently is featured in major financial media as a thought leader on investing and innovation. He holds an MBA from the Wharton School, a BS in finance from Villanova University, and is a CFA charter holder. Welcome, Andres.
Great. Thanks so much for the intro, Sophia, and welcome everybody. Thanks so much for joining us. So I get the pleasure to introduce James in a minute here, but figured for folks that are not as familiar with Zoe, I would take a minute and just describe a little bit on what we do, right? So what Zoe focuses on is on helping consumers, mass affluent consumers, high net worth individuals find the right financial advisor for their situation. We started the company when I was at JP Morgan. My parents were looking to hire a financial advisor. I was the only Wall Street guy, so they asked me for help. And I really struggled to find an advisor that made sense for their circumstance, that had the right incentives, the right aligned incentives and competence. So that's why I left JP Morgan to start Zoe. And our mission will always be to help grow and protect our clients' wealth, right? So what better way to do that by making sure that they hire someone that has the right incentives and is competent in the area that they need the most help. So that's what Zoe does. And hence, obviously, what we put educational webinars on topics like this is very much aligned with our mission. With that, I have the perfect person to help us on this topic to cover today when it comes to estate planning is James Simon. He's a CPA and CFP. He's the founder and president of Renew Wealth Management. He advises high net worth individuals and families on tax strategy, investments, and multi-generational planning. And although James started his own company, he has over 20 years of experience, including large organizations like Charles Schwab, where he helped mass affluent and high net worth individuals, as well as ultra high net worth individuals when he was at Crescent Capital, which focused more on like the multifamily office type service. He worked 5 years in the White House military office, which I thought is one of the most interesting and unique aspects. I love talking to James and learning more and more about some of the things, some of the experience he's had there. He served under the Department of Defense Investment Board. He has a master's of liberal arts in management from Harvard University, and he has a BA in history and economics from the University of Florida. Thanks so much, James, for joining us. It's a real pleasure.
Thank you. Thank you.
So I will let James take it from here, but just to set the stage of a couple items here. One is, here's kind of the areas we're gonna discuss, what may happen after a wealth event, considerations for multi-generational families, reducing the risk of a family conflict, when to act. And then after final takeaways, we will make sure to leave time for questions. So if you have questions, you could always start asking them as we go, but just know that we'll address them all at the end. That way, James and I could kind of focus on first making sure that we get through the material, and then we'll make sure to make it more conversational at the end. So with that, I'd love to turn it over to you, James, to start with many state issues that are not technical here.
Well, thank you, Andres and Sophia. Thank you for the lovely introduction. And yes, my time at the White House, interesting enough, it was really what we say part of one of my jobs, and I'm going to get too many details, was what they call a continuity of government. So think of that as the living will of the federal government. It's pretty interesting. It does
super interesting.
Yeah, pretty interesting. So that's a different matter, but certainly still very close to what we're going to talk about and what I'm going to discuss. So before I dive in, I want to share three key numbers and three misconceptions in one family. So by the end of our webinar, I think you'll all see your own plan a little bit differently. So here's the first number, 84 trillion. So according to the Cerulli and Associates projection, just have you ever heard of Cerulli? It's a Boston-based global financial planning firm that does research. So what they said is that's the number that's going to change hands in the United States between now and 2045. So it's the largest intergenerational wealth transfer in human history, and it's already underway. The second number, I guess you'll probably say two numbers, is 70% and 90%. So a 20-year study of 3,200 wealthy families found that 70% lose their wealth by the second generation and 90% by the third generation. There's an old proverb, some may have heard it, but we say in estate planning, shirt leaves to shirt leaves in three generations. And the last number is 52%. Bank of America's 2024 study found that 52% of high net worth respondents lack all three basics, which is a will, a healthcare directive, and a durable power of attorney. So people with significant wealth,
So
with
more than half of them.
yes, exactly, even affluent. I mean, I've certainly been in business owners and individuals who have even massive amounts of money, $30 million or more have none and with no signature on the most fundamental documents. So,
That's crazy.
many, exactly. So many of you came here this evening or morning, depending on the time, worried about the estate tax. So I have some good news and I have a warning. So the good news is the One Big Beautiful Bill Act, sometimes known as OBA, signed last summer, made the federal estate tax exemption permanent at $15 million per person. It's $30 million for a married couple. So beginning this year and indexed to inflation going forward, for most families on this webinar, federal estate tax is no longer the problem you thought it was. Now, here's the warning. That doesn't mean you don't have an estate planning problem. It means the problem you have is different than what you might thought. And it's the harder one to solve. So now here's three misconceptions. Number one, I have a will, so I'm covered. Your will may not control most of your wealth. So you have maybe you have retirement accounts, life insurance, annuities, and transfer on death titled accounts that pass by beneficiary designation. Those override your will every time. Here's the second one. I hear is my estate plan was done by a great attorney a while ago, so it's done. A plan completed in 2014 reflects 2014's tax law, 2014's family, and 2014's net worth. So the Secure Act in 2019, the Secure Act 2.0 in 2022, and the One Big Beautiful Bill Act last summer have each rewritten material parts of the playbook. And the last misconception is estate planning is mostly about taxes. The technical issues are the easy ones. The hard ones, the ones that destroy families, are about misalignment, outdated documents, untold expectations, conversations that never happen. So, what I like to do at this point is it brings me to a family I want you to meet. So, it's going to call the Jones family, and they're a composite. Every detail is something I've actually seen. So, I'll set the scene. So, we have a family. Robert Jones is 68. He recently retired orthopedic surgeon. Second marriage of 8 years to his wife, Susan, who's 65. Robert has three adult children from his first marriage. David, who's an entrepreneur, Michael, who struggled with addiction off and on for 15 years, and Emily, who hasn't spoken to her father in 4 years after falling out, we'll just say, at a wedding. So Susan has two grown kids of her own from a previous marriage, both doing well. Robert and Susan's combined net worth is about $5 million. So they own a house in, we'll say, Bethesda, Maryland, around $1.4 million. They have a traditional IRA at 1.5 million, a brokerage account with about 1.2 million, and a condo, we'll say in Naples, Florida, about 500,000. And then they also have term life insurance. They have a will and a revocable trust, a living will that was drafted in 2014. They believe everything is in order. They are wrong about that. And here's the thing. At 5 million, they are nowhere near the federal estate tax exemption. They don't have a tax problem, but they do have an alignment problem, and that's a much more common story. So we'll talk about the common blind spots and what may happen in a wealth event. Now, the pattern I see most often isn't a bad plan. It's a plan that quietly drifted out of alignment with the family it was supposed to serve. Three things change while documents sit in the safe, or maybe on your bookshelf, or maybe somewhere else. The law changes, the family changes, and assets change. Anyone can break a plan. So we just go back to Jones. So when Robert had his will drafted in 2014, he and Susan funded a revocable trust by retitling their Bethesda house, which is good. The brokerage accounts, the IRA, and the condo in Naples, Florida, those never got moved. So Robert assumed his attorney was handling that. The attorney assumed the financial advisor was handling that, and the advisor assumed the attorney was handling it. None of them were. So the trust they paid to set up only controls about 28% of their estate. And one thing I always say is that if you set up a trust, you pay an attorney, set up a trust, that's one part. But if you don't actually retitle accounts, I always say that's equivalent of buying a new car and leave it on a lot at the dealership. Now we talk about the Secure Act and we'll talk about the IRAs. Now the Secure Act of 2019 combined with the Secure Act 2.0, that's final regulations that IRS clarified in 2024. So that changed the math for most every non-spouse beneficiary. So before 2020, a 35-year-old, we'll just say a 35-year-old who inherited an IRA from a parent could stretch the distributions throughout their lifetime with small annual withdrawals, which means that's decades of tax-deferred growth. Now that's gone completely for most heirs. Now, most non-spouse beneficiaries must empty an account within 10 years of the original owner's death. So that includes Roth IRAs as well. And if the owner had already started required minimum distributions, the heir generally has to take required minimum distributions during those 10 years too. So here's why that matters. We're going back to the Joneses. Robert's IRA is 1.5 million. If something happens to him and Susan inherits, she's a spouse, so she has spousal options, and so she's fine. But when Susan eventually passes, the IRA goes to a non-spouse heirs. And remember, there's three kids, David, Michael, and Emily, and they're looking at distributions during what are likely their peak earning years. David's already in the top federal bracket, so you force another $150,000 a year of ordinary income onto him for a decade, and the federal and state tax bite alone could really exceed over $500,000 for him. Money that didn't have to leave the family with thoughtful planning. Now let's talk about the Roth strategy, right? So that's one. This is where Roth conversions can play a role for some families, shifting the tax burden away from the heirs by paying the tax now in a potentially lower bracket. So rather than letting it land on the next generation and higher one, it's not right for everyone though. Outcomes depend on bracket, time horizon, and where the conversion taxes get paid from, like which account, brokerage account. But it's a conversation worth having before, not after.
Yeah, that's a really big one. Is that 10-year time horizon is not something people think about when they're setting these, because it might be 50 years down the road. They're like, who cares? And then you get there and the children are the highest earning potential, and now they have now they're paying 40 cents on the dollar taxes wise instead of potentially nothing
Right.
at that
Absolutely.
point.
Yeah, absolutely. And Andres, you mentioned that that can really change, especially of you inheriting some in a retirement account and you have to pull money out and you're already in a higher tax bracket. You're like, hey, I'm paying more taxes.
Yep.
And so that can certainly inadvertently affect you. So when it comes to the beneficiary designations, I do want to really talk about this. So I want you to remember that Robert's wife, Susan, he was married before. He was married before. So this is his second wife, his second spouse to Susan. They divorced in 2008, right? So when Robert moved his old 401k into a rollover IRA in 2009, the form, some of you probably seen this form online or maybe you filled it out. The form asks who the beneficiary was. So Robert wrote down his then wife's name. He's been divorced from her for 17 years. He has not looked at that form since. So if Robert dies tomorrow, $1.5 million does not go to Susan. It does not go to his children. It does not go to a charity. It goes to his ex-wife. It does not matter what his will says. It does not matter what his trust says. The
Mm.
custodian's form is the law of the land for accounts. Remember that. I have seen this exact situation, not the Joneses, but a real family. And a litigation lasted 3 years, and the cost of heirs is over hundreds of thousands of dollars. So this is very critical. How many of you right now can tell me with confidence who is your named beneficiary on every retirement account, every life insurance policy, any annuities you own, any bank accounts? Most people can't. Most people think they can, and then they go check and they're wrong. So always check the beneficiary designations.
That's like the number one. The funny thing is that it's not even for complex things. Like I remember for my 401k, my first 401k, when I first hired an advisor, I was recently married, and the advisor goes to see my 401k. And it's like, who do you have as your beneficiary? And I'm like, I get my wife, I think. And they're like, your mom. And you're like looking at your wife like, no, I promise. I like didn't even know this was said like 5 years ago, 7 years ago. So yeah, I definitely felt that myself.
It happens. I knew of really a client. This was over a decade ago who left the ex-wife on a pension annuity payout, and he had been remarried already. And let's just say that that ex-wife surely got that annuity pension payout from his military pension. So, very key things to look out for any beneficiary designation. Remember, that is what they go by. That is the law of the land. Now, let's talk about the blended and multi-generational family. So, here's an interesting number. Roughly 40% of marriages today are remarriages for at least one spouse. The traditional estate plan template, leave everything to the spouse, then equally to the kids, was built for a family structure that frankly isn't the average anymore. Blended families create a structural conflict the documents have to solve. The surviving spouse needs financial security, perhaps, but the children of the first marriage need confidence that their inheritance won't disappear into the second marriage. If you leave everything outright to the surviving spouse, the kids from the first marriage have no legal claim. The survivor can rewrite their will, remarry, redirect everything elsewhere. This isn't paranoia, it does happen. So we go back to Robert and Susan. They never had this conversation. Their plan leaves everything to the survivor, then to all five children equally. So on paper, it's elegant. However, in reality, Robert dies first. Susan inherits the $5 million. Susan, understandably, prioritizes her own two children. So she updates her will. When she eventually passes, David, Michael, and Emily inherit nothing from the estate that originated from their father. Was that what Robert wanted? No, it wasn't. Was it what Susan intended when they signed in 2014? No, but that's the document they signed. So these are very key things when we talk about setting up structures like a qualified terminal interest property. We call that a Q-tip trust. And all that does is just really allows the surviving spouse to receive income during their lifetime. I won't go deep on the technical mechanics. So that's a conversation for a planner, attorney, and CPA together. The point is, tools exist. They're not exotic. They're not just for billionaires or people with hundreds of millions or $10 million. They're for people, everyday people. So they're easier to use without bumping into any type of transfer tax issues. So if you're in a blended family or your kids are, this is the single most important conversation that you can really have in the next 90 days. So we can talk about the reducing the risk of family conflict because there certainly can be family conflict. Most family conflicts after a death aren't about money. They're about meaning. Whether one sibling thinks mom loved the other more, who got the lake house or the vacation property, whether the executor is hiding something. I always like to say the dollars are the symptom, the relationship is the disease. So here's three questions I have for everyone listening. Ask yourself these questions. If I died this weekend, would my plan reflect what I want today or what I wanted 7 years ago? The second question to ask yourself is, have my advisors, my attorney, my CPA, my financial advisor actually talked to each other in the last 12 months? And the last of the three questions is, have my heirs ever heard from me what I'm intending and why? So if you can't answer yes to all three, your plan has some drift. Because estate planning sits at the intersection of three professions that rarely talk. You have your state attorney, you have your CPA, and you have the financial advisor. Each is competent in their own lane. None of them by default looks at the whole picture. The CPA doesn't know your trust funding status. The attorney doesn't know your beneficiary designations. The advisor doesn't know your latest will. In the absence of someone quarterbacking, gaps do appear. So here's what I want to tell you, the version of the Jones stories I want to tell more often. So 18 months before Robert had a heart attack, his daughter-in-law, Sarah, David's wife, convinced Robert and Susan to sit down with the planner who insisted on bringing the attorney and the CPA into the same room. So getting both professionals. And they had a couple of meetings. During those meetings, they retitled the IRAs. They moved the brokerage and the condo from Naples into a trust, a living trust. They restructured the plan with the Roberts' three children as to remain the beneficiaries. They had what the planner called a family meeting. In family office, we used to have that term, a family meeting, we call it simply. A phrase Robert had rolled his eyes at. So when Robert sat all five children down and explained in his own words what he wanted and why, Emily, who was their strange daughter, came. She and Robert, now they didn't reconcile that day, but she came. When Robert died 18 months later, the plan worked the way it was designed to. Susan was financially secure. The kids inherited what their father intended. The litigation never happened. And this is the part I think about the most. Emily was at the funeral. So here's when to act. And these are very important. And there are five triggering events on when to act. You've inherited assets, or you expect to. You've remarried, or your child has. You had a liquidity event. That could be you sold a business, you have some vested options, you have a settlement, maybe even purchase real estate. Your net worth has changed materially in either direction. And the last is your plan hasn't been touched in 5+ years, or it predates the One Big Beautiful Bill Act, which is everyone whose plan is older than last summer. So if you're sitting there mentally checking off two or three of these, that's not a coincidence. That's probably most of this audience. So here are my final takeaways. Very key. Here's what I ask you to leave with. Estate planning is not a document, first and foremost. It's not even a set of documents. It's an ongoing conversation between you, the people you love, and the professionals you help protect. When that conversation is current, the documents take care of themselves. Now, when it goes silent for a few years, the documents have what we call drift, quiet, invisibly, until something happens that pulls back the curtain. The Jones family I described is fictional, but every problem they face is something I've really watched families work through on both sides. The side where the conversation never happened, the side where it did, the difference is real. And the only thing that decides which side a family ends up on is whether they had the conversation while there was still time to have it. So at this moment, I'd definitely like to take any questions.
That's great. Thanks, James. That was super helpful. I have a couple questions that have come through it, so maybe I'll start with one, and then as others trickle in real time, we'll go through them. So the first one is, a lot of people watching today probably have an estate plan they haven't touched, 5 or 10 years because it's a hassle, right? To go over old plans. At what point does an old plan become more dangerous than having no plan at all, right? What's like the expiration date on legal documents in your eyes?
Yeah, so that's definitely a great question, Andres. And it's one most people don't want to ask because they're afraid of the answer. So legally, your documents don't expire, right? Practically, they do decay. And here's the part most people miss. So a stale plan is often more dangerous than no plan at all. Here's why. Because no plan means your family knows they have to deal with it. A plan from 2014 means everyone assumes mom and dad have it handled until they don't. So I tell clients there are three expiration triggers. Any one of them, and the plan needs a fresh look. So number one is the life event. There's marriage, divorce, a new grandchild, even a major health change. Now, number two is an asset event. So that's the new business, a real estate purchase out of state, or a liquidity event. Or the last, which is going to be a law change. And we've had three big ones in the last 5 years. Secure Act 2.0, and OBA. So absent any of those, my rule of thumb is 5 to 7 years, typically. Beyond 10 years, I'll tell you flat out, assume it's broken until otherwise. The most painful version I see is what we call a formula trust, drafted when a federal exemption was like 1 million or $2 million. So the formula automatically funds a bypass trust up to the exemption amount. So today, with a $30 million couple exemption, that same formula can funnel really the entire estate into a trust that locks up the surviving spouse and loses the step-up basis on a second death, solving a tax problem that no longer exists. So if we go back to
Right.
like the Joneses plan, which was written in 2014, if their attorney used a formula clause, this is exactly the trap that they're walking into. So this is why you do want to have your documents updated, but 5 to 7 years, give or take.
That's great. That's super helpful and actionable for people that have one in place. So I have a couple other ones here that have come in real time. One is, what is the actual price of doing nothing, right? If I leave a plan misaligned and it ends up in probate, are we just talking about a short delay, or could my family be looking at years of legal fees and significant chunks of their inheritance lost? Like, what's kind of the damage that do you see using maybe an example or two, but in the sense of like, what have you seen?
Yeah, I mean, the damage, if you do nothing, and it really is, I always say number first and foremost is that it doesn't matter if you have 30 million or 30,000, 50,000. you want to have some type of will, a trust, some type of estate plan in place. It's very important. If you don't, then you're going to have what we say is, or if someone doesn't, it's probate. And I'm willing to bet that maybe someone in the audience has either gone through probate or known somebody who's gone through probate. And I could tell you, it is a very laborious process.
It's not just the money. Let's put it this way. Is the work associated with it.
Correct. You literally have to either, go to court, go to a magistrate, going back and forth, gathering documents. It's very, very time consuming. And on top of that, maybe perhaps you have to go to another state, you have to fly. So to me, I always like to say, if you rather have the government out of your business, please have at least some type of living will at bare minimum.
Yeah, yeah, no, that's great. Okay, we have another one here. We're already taking care of our kids and want to support a cause that we love. Is charitable giving just something I tack on at the end of the will, or can I set that up to get a tax break? Like maybe talk a little bit about that component of things.
Yeah, absolutely. So there's many charitable planning is part of estate planning, and it's quite common. I mean, last year the Americans gave over $30 billion to charities or organizations. So it's very quite common. What you can do before, you could set up what we say is a donor advised fund. That's usually if you want to actually give money today and you get a tax break. There's also different types of trusts called a charitable remainder trust. So that just means that, hey, if after you pass away, everything, the remainder goes to a trust that eventually gets paid out and then goes on to the charity. So there are definitely different tools. I would say, speaking with a competent estate attorney or professional, estate professional is very key to really narrow down what are your wishes and what are your goals. But there are absolutely vehicles and ways that you can be able to um, meet your obligations, or I would say obligations, but really meet your wishes of providing to a charity and at the same time providing to beneficiaries that could be family or loved ones.
Okay, great. So I got another one here. It's related, but if someone had their estate document drafted in one state, you mentioned, hey, you might have to travel, but now spend significant time in another. Do those documents travel well? That's the question.
The short answer is no. Typically, I always like to say, again, you want to have your documents updated based on where you're domiciled. So if you are, you have a home, for example, a vacation house or winter house in Florida or maybe Texas or somewhere else, but you're really spending most of your time in Virginia, Maryland, or New York or somewhere, you really do want to make sure what laws apply, even based on where you're domiciled, because that's very key. If you think about it, even just the tax code is based on, kind of how many days do you spend per year at one location, right? So it's typically over 180 days in, let's say, one location, you're probably likely a resident. So I would say you want to really look at updating, speak with, again, a competent an estate attorney or professional to really find out specifically if you need to update and make sure you address any type of gaps you may have so that, again, if you one, God forbid, you pass away in one state that you're not a domicile, that you're not a resident of, then you could wind up but your documents are another state. You really want to make sure which one is going to be, I like to say, the primary for what
Yeah.
happens.
Yep, that makes sense. Another question is, James, if I were to the question saying like if I were to work with you, would you help me find the estate planner? Like how would that does that usually work with?
Yeah, absolutely. So we actually do use a network of estate planners or really estate attorneys in all 50 states, or I would really say 54 states and territory. So again, that is based on, again, working with a network of different attorneys who are very professionals in understanding different ones, different laws, even to include international, because sometimes there are individuals who own international property. Maybe they have a home in the Caribbean, maybe they have a house in Europe, or maybe they're inheriting. And those are actually governed by different types of laws completely. And you really want to have and a state attorney who really understands international law, because I've seen cases where family members may have land in, another country, and they pass away and they thought that their trust in the United States would cover that. That's not the case. That is not the case. So we do use a network of attorneys and that can actually work with you directly, and we work with them as
Right.
well. So it just means that we're always in the conversation with them.
Got it. Okay. Got a couple more. Keeping an eye on time. We have time for a
Mhm.
couple more here. This one's a good one. So, what financial habits do you value the most so I could teach my future family? So, this person doesn't have a family yet, but yeah, you could obviously look, everyone might have different values, but they're asking specifically which ones do you value the most? Maybe from the 1,000 lives you lived, helping different folks when it comes to their estate planning.
I think the most important is really, I think that the very key, and that's education. Um, you can give money, let's face it, you could give, millions of dollars to a child or to someone, but if they don't really understand financial literacy or have a good foundation on education and finances, then it's not going to work. I've seen that. I've seen people, unfortunately, even at 40 years old or 50 years old, inherit hundreds of thousands of dollars, even the millions of dollars, but they never really had a good foundation and an understanding of finances and education, and they blew it. They literally blew it. And those are very sad cases. So I always like to say, hey, if a person can't handle $5,000 or $50,000, they're not likely going to be able to handle 500,000 or $5 million. So it's really going to start with what I say is education, making sure education, financial education, is a part of the conversation when it does come to not just estate planning, but really in general, just all types of financial planning in general. So those are, that is, I would say, the one kind of holy grail I've seen the success is that, again, uh, we've seen those not just athletes, but we've seen people who have coming in millions of dollars or earn millions, and then you read about them months or years later, and you find out, hey, they're insolvent. They don't have any money, and most of the time, it's just because that they never had a great foundation on truly education, financial literacy, and a good foundation for that.
As a follow-up question, James, this is me asking, is when do you see um, people starting to that educational process? Like what age usually for their children, right? Like is it as early as possible? Is it more like as teenagers? Is it,
I like to say, as soon as your child comes to you and asks you for money.
that's good.
So, so I, so I tell you,
So I should talk to them now. Got it.
absolutely. There's never a age where it's too young. I remember when my son came to me, all right, 9 years old, and asked me for money, just blanketly asked me for $100. And and he just like, "Well, what are you gonna do with it?" I was like, "I'm just gonna go, go buy some candy and everything." Before I gave him $100, I actually went on Amazon and ordered about 4 or 5 children's books, like literacy books on finances, the understanding. And I said, hey, before I give you any money, I want you to read these books, or at least
Creating some incentives.
there you go. You incentivize them. Their kids are never too young. It's never too young to really, and there's never too late. So I always say the earlier, the better. Again, this is all about building a foundation, because let's face it, you could go through college in graduate school and not really have a good grasp on finances and
Sure.
investing. Is really not taught today at the high school level, barely in college, unless you want to take, certainly electives, and in graduate school. So an earlier foundation is better. So again, there's no such thing as too young.
Yeah, that's great. So we have time for two more questions here, and I'm this came basically the last one was asked a few times, so I saved it for last. But this one is Why do you choose to become an advisor? Like everyone has their different journey. Why do you choose to do the profession? Sounds like you could have gone in a lot of different directions based on your background and your qualifications. Why do you become an advisor?
You know, I definitely, that is a great question. And the truth is, became an advisor to really help my family first. So when I was growing up, I unfortunately watched my own parents make financial decisions, which eventually led to divorce. And by the way, the leading cause of divorce is finances, bad financial decisions. So I actually watched them as a teenager, late teenager, go through divorce process. And that stuck with me. And so, seeing my mom at the time who had a lot of her money into CDs, not having invested, and then my dad who had a lot of his money in company stock, that eventually wound up really falling and going bankrupt. Those were two things that I said to myself, hey, had they had the education, then they could have been better off and they probably could have been still together. Who knows? I don't know.
Mm.
But certainly that led me, and then going through college. And of course, when you go to college, I remember undergrad at University of Florida, you see all these, tables out there at the time I was there, and they had like, hey, sign up for credit card, American Express will give you a t-shirt and Visa and all these, and all these, students, and they're just signing their name away, not under truly understanding what they're doing and that how that's valuable. And so I got into this really first and foremost to help my parents out, which I definitely have done to this day, and but really to help others, to help other individuals and families. Because one thing I absolutely say and believe in is that, you know, finances, managing your personal money, it doesn't matter, your race, your color, your religion, any of that. It affects everybody. I've seen it affect many families. And so if I got into this really help my family, but more importantly, to help other families. And
Yeah.
that's really my passion for what I do and why I got into being a financial advisor.
That's where we'll leave it, James. Thank you so much for your time and for your insight